Good morning. Thank you for joining us bright and early on day 2 of Hong Kong Arbitration Week. And to those of you who are joining us from outside Hong Kong, we're very much hoping we'll be able to see you back here in person soon. My name is Cameron Sim. I'm an international counsel in the International Dispute Resolution Group here at Debevoise in Plimpton, based in Hong Kong, where I specialize in commercial and investment treaty arbitration. Now, occasionally in Arbitration Week, it can be quite difficult to discern from the seminar's catchy name what the seminar will actually be about. I hope that is not the case for our webinar today. The label will be matching the contents, and our discussion will be on fraud in arbitration and how to overcome limitations on tribunal powers in this context. We have an incredibly experienced panel discussing these issues with us today. From Debevoise and Plimpton, we have 4 partners joining us from the International Dispute Resolution Group. From Hong Kong, joining us are Mark Johnson and Gareth Hughes. And joining us from New York are David W. Rivkin and Natalie Reed. As many of you will know, David is also the co-chair of the HKIAC here in Hong Kong. We're delighted also to be joined by our external panelists today. Swee & Co is based at Wong Partnership in Singapore, and Qian Bao is an arbitrator based at Arbitration Chambers, also joining us today from Singapore. So thank you both very much for collaborating with us for this event. Moving through then already to the roadmap of today's discussion, we're covering a lot of ground. We'll be keeping it fairly fast-paced, but there is a bit to get through. We'll be starting off just giving some more context to the topic of fraud in arbitration, and particularly the recent experience our team here in Hong Kong has had on this matter. That will include discussion as well on the abuse of confidentiality restrictions that might arise in the context of fraud cases and what can be done about that. We'll then be having 2 main discussions. In the first discussion, we'll be looking at the tools that are available at the tribunal's disposal in cases concerning fraud, specifically at looking at adverse inferences and peremptory orders. And we'll be asking the question as to whether those are sufficient to encourage compliance with tribunal orders in cases involving fraud. We'll then be moving on to our second main topic. When those tools at the tribunal's disposal are not enough, what tools are available to the courts? And when and how may court applications be pursued in support of claims in arbitration? In this discussion, we'll be looking at a few tools the courts have available to them, including disclosure orders, specifically focusing on Norwich Pharmacal applications and Bankers Trust applications. If you're not familiar with those, you soon will be. We'll then turn to freezing injunctions, the rather draconian remedy of receivership, and finally, where there are parallel court and arbitration proceedings, the prospect of contempt proceedings being used to put further pressure on the other side. Now, please feel free to raise questions at any time. It's the usual format for Zoom, so you can type questions into the Q&A box, and I'll do my best to have those addressed to the panelists, either during their presentations or at the very end of our webinar. With the time remaining, we will have a final Q&A session. So with that, it's my pleasure to hand over to David.
Cameron, thank you very much for the introduction and for your work in organizing this webinar. We are really delighted to be able to present it during Hong Kong Arbitration Week, which we know is a very, very busy week, and we thank all of you for joining us this morning. We're very grateful to you for choosing our webinar, and we hope and are sure that you will find it interesting. We'll do all our best to make sure of that. I'd also like to extend our thanks on behalf of the firm, particularly to our 2 guests, Swee Yen and Chan, for joining us today from Singapore. Their contribution will be incredibly important to the webinar. As Cameron mentioned, I'm honored to be serving as the co-chair of the HKIAC. Our firm's connections and my own personal connections to the HKIAC go way back. I think the HKIAC deserves a lot of credit for maintaining a strong and very interesting arbitration week, continuing that tradition throughout the pandemic through a series of webinars like this, as well as the HKIAC's own program coming up later this week. I very much hope that next year I'll be able to attend Hong Kong Arbitration Week in person and look forward to seeing many of you there. As I mentioned, we at Debevoise are very proud of our association with the HKIAC and our history, long history of arbitration in Asia. We have a strong record of acting in both commercial arbitrations and investment treaty arbitrations in the region. In fact, I can say that this week I'm extremely busy getting ready for a week-long virtual hearing starting on Monday, a week from tonight, on behalf of a large Korean client in an ICC arbitration against an American firm. Our firm has the benefit, as most of you know, of a full arbitration team, not only on the ground in Hong Kong, but also in New York, London, Paris, and Moscow. Our Hong Kong team, and many of whom are speaking tonight, or this morning, I should say, also has, works very closely with the rest of our international disputes team in the rest of the world. One key benefit of that, of course, is that we can truly offer 24/7 services to parties based in Asia in complex and demanding cross-border cases, particularly in cases involving fraud. Cannot overstate the significant benefits this brings to our case. I've worked on some of the cases that are described tonight, and it truly was 24/7 as people in London turned the work over to New York then turned over to Hong Kong, and it circled back around the world. In any event, I just want to make clear what we are talking about this morning, and that is when you find yourself in a situation where you're in an arbitration with individuals or a company that you are sure has committed fraud, and in fact the fraud is really at the core of the dispute that's led to the arbitration. And you'll hear some examples as we go forward tonight. What we're not talking about is an occasional fraud that a party might try to pull in an arbitration, or parties using arbitration effectively as a fraud on the market as a means of transferring funds, for example. I'll give one quick example of the former of those two types of frauds. I had a case a number of years ago where we were representing an Asian client in an arbitration against an American client. And just a few weeks before we were going to hearing, the American client suddenly produced some documents that they said their Asian office had found, including one document, a letter signed by our client's CEO that had a number of damaging admissions in it. We sent it to our client. Our client said they'd never seen this letter before. They were sure it had never been written. I asked them to check their files. They came back the next day and said there was nothing in their files. So I sent it to a handwriting expert who it took less than 30 minutes to determine that it was a forgery. The signature line was not on the same parallel as the typing in the rest of the letter. It was just slightly off, but enough to be clearly a forgery, clearly a cut and paste job. So I called up the lawyer for the other side, who was also based in New York. He came over to my office. I showed him the proof of the forgery, and in less than 48 hours, we had a full settlement of the case for the full amount that we had been seeking in the arbitration. So that was an example where fraud was certainly found and worked very much against the fraudster. But tonight we're going to be talking about fraud and arbitration, more generally fraud or arbitration against fraudsters, for want of a better term. And my first observation is that fraud has a significant impact on the victim's rights and the procedural norms. There's a well-known saying in English law, as you'll see on this slide. It's cited frequently with approval in many common law jurisdictions. Almost 70 years ago, Lord Denning said, "Fraud unravels everything. The court is careful not to find fraud unless it is distinctly pleaded and proved. But once it is proved, it vitiates judgments, contracts, and all transactions whatsoever." In other words, fraud is very hard to demonstrate, but once it's been proven, fraud displaces all other norms and all other rights. Courts and tribunals are very careful, because of the seriousness of fraud, not to accept allegations of fraud where it has not yet been proven to a high level of satisfaction. particularly at an early stage of the proceedings. We'll talk about the consequences of that in a minute. But in the interim, the acts of fraudsters can be quite bold, quite audacious, and they can risk derailing the entire dispute resolution process. That's why we hope this webinar will be helpful to all of you. My second observation is really in the form of a question. Does fraud have the same impact in arbitration as in litigation? In short, in our view, the answer is yes. The types of fraud that can be encountered in litigation or arbitration are essentially the same. In both, fraudsters can have no hesitation in engaging in forgery, presenting false evidence, breaching orders and directions, and even taking deliberate steps to evade orders. The impact of this will be the same before a court or an arbitral tribunal. Hurdles and obstacles will be placed in the way of the pursuit of truth, and it's only with patience and perseverance that the victim can overcome those obstacles. But the difference between litigation and arbitration lies in the powers of the decision makers to deal with the impact of the actions of the fraudster. And as the topic of today's webinar suggests, fraud does test the limitations on tribunals' powers. The presence of fraud in arbitration may require parties to enlist the assistance of the courts where appropriate to help unravel the fraud. My third observation is that where fraud is suspected, preemptive steps are important. They're indeed vital, particularly when the parties have agreed to resolve the dispute through arbitration. The presence of fraud doesn't excuse a victim from complying with a valid and binding arbitration agreement, with the caveat that difficult issues can arise where a party alleges that an arbitration agreement itself has been forged. But a party obliged to resolve a dispute through arbitration will need to prepare for the likelihood that ancillary court proceedings will be needed in order to support the claim in arbitration. As we will explore today, there are several different options to consider at the outset of a dispute. Where fraudsters are involved, parties must prepare for unexpected developments. If a party fails to take preemptive steps against fraudsters, enforcement difficulties are very likely to occur. Strategy and planning and long-term planning is therefore critical, especially in these cases. So turning now to how this plays out in practice and our own experience with this. In a recent case led by our Hong Kong team, our clients faced serious acts of fraud being committed against them in the private equity sector. Ultimately, our firm secured arbitral awards for our client valued at $1.7 billion US. But preemptive steps were taken throughout the arbitration and we were able to use those preemptive steps to lead to monetization of those awards within 1 year of the awards being issued. Even in a standard arbitration involving sophisticated parties without elements of fraud, this rapid result may be unusual. But what this demonstrates is that if you not only keep up with the other side that's committing the fraud, but in fact stay ahead of them by preempting various steps and putting in place certain protections, you may be able to position yourself to be in a stronger position than if you had not taken those steps. So if you're against people who you believe have committed fraud in arbitration, there are 4 main phases that you may experience as set out in this slide. Let me elaborate. The first phase is that they will delay taking procedural steps or providing answers or materials for as long as they possibly can. Such answers and materials as the fraudsters do provide are likely to be wholly inadequate and incomplete. They'll seek extension after extension and come up with excuse after excuse for requiring them. The key risk you face during this period is that fraudsters will be trying to stay ahead of the curve. They're unlikely to be sitting on their hands and scratching their heads during this period. Instead, they're likely already to be taking steps to place assets out of reach and to cover up the fraud. So during this phase, preemptive steps, which we'll come to, are particularly vital. And this phase and the next phase are often more difficult for the victim, because at this point, the arbitrators have not yet figured out that the other side have committed fraud or may be trying to take these steps. As we know, arbitrators, and it'll be interesting to hear Chan's perspective later this morning, arbitrators often will take their time in coming to judgment about the nature of the parties and the conduct of the parties, because they're trying to be fair and not come to any rush judgments. So doing what you can to show the arbitrators who they are dealing with as early as possible is also very important. And that is the second phase, the counterattack. The fraudsters will often try to shine the spotlight away from them and onto the victim. In other words, a counterattack, a classic attempt at blame shifting. We have all seen others accuse us of what we know they have done in order to cover over their wrongdoing. So depending upon the severity of the fraud at this stage, it's important for you to undertake your own counterattack, to begin to show the tribunal the nature of the fraudsters. They may make wild accusations, file counterclaims, and even commence proceedings against the victims. And you have to make sure that the tribunal understands what's truly going on. The third phase is that eventually the fraudsters may feel compelled to provide some answers or information to the tribunal. These answers, though, may be likely to confuse matters even still. Fraudsters will take positive steps to encourage mistaken beliefs and to mislead the tribunal, both by omission and through intentional misrepresentation. They'll try to prevent discovery of their fraud by committing more fraud. During this phase, fraudsters will create forged documents, provide false evidence, and evade directly answering questions or addressing issues. This is likely to necessitate several rounds of correspondence and submissions before any progress is made. But again, you want to be educating the tribunal as to what is truly going on throughout this. At the same time, it's possible that during this phase, infighting might break out between the fraudsters themselves, and we have seen that in some of our cases. The pressure will have been mounting, and finger pointing may begin internally as concerns rise that the fraud may be uncovered, or there may be internal disagreements as to how to cover it up. This can create even further procedural complexity. Where a corporate entity is involved, it is possible that two or more legal teams might suddenly purport to be representing the same client. As the blame game goes on, you may be faced with a revolving door of legal representatives acting for the other side. They may not be able to represent to the tribunal what the fraudsters want to be said, and they may become aware of falsehoods and compelled to withdraw their representation. Suddenly, when new lawyers appear, they have new grounds to delay. So important at this stage for the victim to hold firm and continue to push for determinations from the tribunal of its claim and to stick to the procedural schedule. Finally, the fourth phase is ultimately that tribunals or courts may start to crack down on the fraudsters once you have proven to them who they really are. They'll issue various orders, impose sanctions, ultimately issue arbitral awards in your favor. But even despite the tribunal siding with the claimant, if preemptive steps have not been taken before this fourth phase, it may be a case of too little, too late. The tribunal will only discover where the fraud lies in the case after the passage of significant amount of time. The challenge for every party is to minimize that time period while taking whatever steps they can in the interim to ensure that if an arbitral award is rendered in their favor, it will be quickly and effectively enforced. With that, let me turn it over to our other panelists, including first Mark Johnson, our partner in Hong Kong, who will discuss the issues of confidentiality and how they impact cases like this. And then others will turn to some of the preemptive action that I've been describing. Mark, all yours.
Okay, thank you, David, and thank you to all of you for joining us today. And I'd also like to extend my thanks to Surian and Chan for joining this seminar. So the topic I'm going to look at is confidentiality and how fraudsters may take advantage of confidentiality provisions either in the underlying contract, which is has an arbitration clause in it, or taking advantage of the confidentiality provisions in the arbitration process. Now, as we all know, one of the principal advantages of parties agreeing to arbitrate is that the whole process is confidential and away from public scrutiny. But there are occasions, and this happens in particular, where you have a party who is conducting itself fraudulently, where publicity in a court system can have advantages to a claimant, because an individual that might be subject to publicity in a court or adverse comments by a judge, which are then publicized, may be more persuaded to settle a dispute than would be the case if the matter is behind closed doors in an arbitration context. Now, we've seen fraudsters taking advantage of confidentiality provisions in a number of ways, similar in a way that we've seen with some parties to some of the recent Me Too cases where claimants have been tied up in NDAs, non-disclosure agreements, in a way that has gagged them from discussing a particular matter. And we've seen parallels with fraudsters in an arbitration process. So perhaps at the front end of this, we see fraudsters who will hide behind confidentiality provisions in agreements, preventing parties understanding the information they need to know to ascertain whether the contract is being fulfilled. So in particular, in a recent private equity case that we're involved with, the general partner in a limited partner agreement relationship held back vital information about certain of the assets held by the fund, and did so for a period of 18 months or so, which made it very difficult for the limited partner to seek to understand what had happened to his investments. Oftentimes the excuse for not providing this information is that it's confidential, or that there are constraints on the information that can be provided to a party under the relevant contract. Obviously there are dangers from a fraudster's perspective from relying too much on confidentiality, because if you commence an arbitration which may have some injunction or other preemptory orders attached to it, a failure by a party on the other side to be transparent about what's happening may often provide justification for an arbitrator in an emergency measures context or in a court-appointed context to provide reason to appoint a receiver, which I'll come to later today, or to grant an injunction pending the arbitration itself being fulfilled. So once the arbitration has started, we often again see confidentiality being used as a reason to delay or complicate disclosure during the process. So you may have, for example, arguments about whether certain categories of documents can be disclosed in the context of the proceedings, either because of confidentiality arrangements which are agreed between the parties, or where third parties are involved. And where third parties are parties to confidentiality arrangements, that can also provide a party to an arbitration with a basis to seek to limit the disclosure or to put some sort of parameters around it. We've been involved in cases where documents have been presented on a heavily redacted basis in a disclosure process because of alleged reasons of confidentiality duties owed to third parties. So outside of the discovery process, I wanted to refer generally to now Section 18 of the arbitration ordinance in Hong Kong, which Cameron has put up on the screen. Hong Kong is slightly unusual in the sense that the arbitration ordinance here contains an express provision relating to the obligation of parties to confidence in the context of an arbitration. I think in most other arbitration institutes, it's implied as opposed to being expressed. And you'll see there the particular terms of the provision. Now, in a Hong Kong context, there has been little jurisprudence as to what the precise terms of that provision mean. And you'll see that one of the particular phrases I just wanted to focus on a bit at the moment is the exception in subsection 2, which says that nothing in provision 1, which is the provision creating confidentiality, prevents the publication, disclosure, or communication of information referred to if the publication, disclosure, or communication is made to protect or pursue a legal right or interest of the party. Now, at first blush, that gives quite a broad gateway to a party to an arbitration to use material which has been disclosed or come up in the arbitration, e.g. making court applications and so on and so forth, ancillary to the arbitration. But there can be cases where it's not entirely clear whether that provision does provide a gateway. So, for example, if material is disclosed in the context of a arbitration that suggests a criminal offence has been committed and warrants a complaint to the criminal authorities, query whether that is protecting or pursuing a legal right or interest of the party. Now, in circumstances where there may be suggestions that if a party discloses information even to law enforcement that the party so doing has been in breach of confidentiality arrangements, either in a contract or associated with the arbitration itself, the option that is available to a party to an arbitration proceeding, and we did this recently, is to go to the arbitration tribunal to get specific consent to use the information that has been disclosed during the course of the arbitration for purposes, e.g., making complaint to a regulator or to law enforcement. Right, so that's all I had on that aspect of things. Hand back to Cameron.
Thank you very much, Mark, and also to David for that very helpful overview of fraud in arbitration, the types of antics that might be faced whilst proceedings are on foot. Now, we have already mentioned that there are limitations on tribunal powers in this context. However, tribunals do have some tools at their disposal, which can really be of utility in cases such as this. So we'll move now to our first discussion and discussing what two of those key tools are. Firstly, adverse inferences, and secondly, turning to peremptory orders before hearing an arbitrator's perspective on using both of these tools. And so with that, I will hand over to you, Natalie, to discuss adverse inferences.
Thank you very much, Cameron. I join my fellow panelists and previous speakers in the thanks for the preparation, to our colleagues for the participation, and to the audience for your attendance. It is my great pleasure to join you all today, this evening, from our New York office, but actually from Jamaica. I had a few technical difficulties earlier, so it's a little bit darker than it would ordinarily be, but hopefully all can see and hear me well. So talking about adverse inferences, frankly speaking, is probably unlikely to strike fear into the hearts of committed fraudsters. But as we will explore, the threat of adverse inferences, even if it may not be sufficient standing alone to encourage compliance with tribunal orders by fraudsters, as experienced arbitration practitioners and court litigators may know, adverse inferences can nevertheless be a useful tool to help obtain the result that a party needs from an arbitral tribunal. You will hear from the other panelists as we continue today that it is still vital, of course, to ensure that other preemptive steps are taken. Both David and Mark touched on that earlier. And ultimately, the goal is to ensure that do our best to ensure that efforts to prevail against fraudsters are not moot. They're not ultimately futile when the time comes to enforce the arbitral award. So let's begin at the beginning. What precisely is an adverse inference? So broadly speaking, an adverse inference is a presumption made by an arbitral tribunal from a party's silence or failure to comply with an order of the tribunal to produce documentary or witness evidence. And it's the presumption that the unproduced evidence would be adverse or harmful to the interests of the party. So again, just speaking very broadly and to boil it down, the tribunal will presume from the party's failure to produce that that evidence, the missing evidence, would be harmful to its interests, would be harmful to its case. Now, there's a fair bit packed into that description, so we'll begin to draw that out now as we move to the next slide. So first, how can the tribunal make such a presumption? Now, the power to draw adverse inferences originates from arbitrators' discretion to evaluate the evidence placed before them. Now, this discretion is codified in most arbitration rules and has now also been included expressly in the IBA rules on the taking of evidence in international arbitration, and also in some national legislation. Now, not all arbitration laws will expressly permit adverse inferences. So in the context of international arbitration proceedings, it remains prudent to explicitly incorporate the IBA rules into procedural order number 1, or to have that procedural order expressly provide that the tribunal may draw adverse inferences. And the resort to adverse inferences in arbitration derives, of course, from the fact that tribunals are generally unable to employ the same coercive measures available to courts to compel the production of evidence. You know, tribunals can't hold parties in contempt or impose the other kinds of punitive sanctions that are typically available to courts. Now, while in some jurisdictions, such as Hong Kong or the United States, the courts are empowered to assist tribunals by ordering the production of evidence. This isn't available in all jurisdictions. Now, we'll talk a little bit more about what those court orders might look like a little bit later in our discussion this evening. As with all tribunal powers, however, if we move to the next slide, just because the tribunal may be entitled to draw the adverse inference, that doesn't mean that it will in fact do so. Ultimately, it comes down to advocacy. Whether the moving party is able to persuade the tribunal that the failure is serious enough, that the missing evidence is critical enough to warrant this relief, or whether the other party is able to credibly explain the failure to produce the document or the witness. Now, if a tribunal accepts that a document has genuinely or innocently been lost or destroyed, rather than deliberately withheld, then no adverse inference should be drawn. The IBA rules, for example, will provide that an adverse inference may only be drawn where the party fails to produce a document, and this is a quote, without satisfactory explanation. So while adverse inferences and the pressure that they create are useful in encouraging parties to comply with evidence production orders, they should be handled with care. So I'll give just a couple of examples to illustrate that. Now, a difficulty that often arises is defining the precise inference that is reasonable to draw from a document that the tribunal hasn't seen or a witness that they haven't heard. The document might be unfavorable. That's the whole premise of the adverse inference request. But exactly how it is unfavorable may be difficult to assess without seeing the precise content of the document. This then creates somewhat of a difficulty for the tribunal if it were to set about by itself attempting to define the inference that is to be drawn and how that feeds into its award. So in practice, perhaps unsurprisingly, tribunals often require the requesting party to specify exactly what adverse inference should be drawn from the other party's failure to produce the document or the witness. Now, the tribunal will often also invite submissions from the defaulting party as to the inference that the tribunal is being invited to draw. This is the opportunity for the advocacy that I mentioned earlier. But the second difficulty is that even where the inference has been so defined, and even where both parties have had an opportunity to be heard and an opportunity to persuade the tribunal, there remains the potential for an application for set-aside of the award. So you can imagine the scenario. If the tribunal's final award ultimately rules against the party against whom the adverse inference was sought and granted, that party might seek annulment of the award. The argument would be that the award was made on an inference rather than evidence actually set before the tribunal, and thus violated that party's due process rights. Now, this risk can lead tribunals to be particularly cautious when expressly relying on adverse inferences in their awards. In my own experience, for example, I have not been involved in a case where a tribunal rested its final decision on the merits of a claim on an adverse inference. Now, that wouldn't inoculate, so that caution, that sort of wanting to make sure that it isn't ruling on the entire case on the basis of an adverse inference, wouldn't immunize the award, so to speak, from challenge. But it is generally a prudent course of action that I've seen tribunals follow. Again, I'd be very interested to hear Chan's views later. So broadly speaking, that's a high-level overview of the use of adverse inferences in arbitration. And as I mentioned at the start, a hardened fraudster is unlikely to be moved by the threat of adverse inferences and suddenly start complying with tribunal orders. But the drawing of the adverse inference is useful and remains a useful arrow in the quiver, so to speak, because it might ultimately assist the innocent claimant to secure a final award in its favor. So with that, I hand it back over to you, Cameron.
Thank you very much, Natalie, for countering through adverse inferences and really helping to unpack what they are. I found that, speaking for myself, very, very helpful. So that's obviously a tool that is at the tribunal's disposal that can be very useful when it comes to drafting their award. But of course, you may be looking for some other measure that can actually be issued by the tribunal whilst the proceedings are still on foot to encourage compliance with existing orders. And so there, enter the peremptory order, and I will now hand over to Gareth to explain to us what peremptory orders are and how those might be used in practice. Thanks, Gareth.
Thanks, Cameron. So as Cameron says, I'm going to spend the next few minutes looking at peremptory orders. It's stating the obvious that the refusal or failure by any party to comply with tribunal orders can have a very detrimental impact on any arbitral proceedings. And as we've seen and as has been discussed, fraudsters more than anyone will use every tactic in the book to delay the process and to continue to cover up any of their wrongdoing. And frequently that takes the form of refusing to comply with tribunal's orders. So what can you do if you're on the other side of such shenanigans? Well, this is where peremptory orders come in. These obviously sound menacing, but the question is, are they effective in practice? I think, as I'll come on to discuss, in reality, even these are not going to secure fraudsters' compliance with tribunal orders. But that said, they are definitely a very effective tool in terms of turning up the heat against fraudsters, and potentially providing a basis for an application to court in due course, should it turn out to be necessary. So what is a peremptory order? Well, in short, it's an order that requires compliance with an earlier order, failing which a sanction, which needs to be set out in the peremptory order itself, will apply. So those familiar with the common law system, essentially they're like unless orders. So in other words, unless you comply with the provisions of the order, you will face certain consequences. So turning to Hong Kong, as you'll see on the slide, if we can bring up the next slide, the Hong Kong Arbitration Ordinance provides for a range of sanctions once peremptory orders have been disregarded by a party. The sanctions available to tribunals in these circumstances include drawing adverse inferences, which Natalie's just taken us through, barring parties from relying on unsubstantiated allegations or material, as well as adverse costs orders. I think in practice, peremptory orders are often used by tribunals as a form of formal warning to the defaulting party of what may follow, and essentially as a sense of the direction of traffic of the tribunal's thinking, unless that party falls into line. If ultimately a peremptory order continues to be ignored, then the defaulting party is at risk of the sanctions being imposed that are set out in the peremptory order. Now, as you can imagine, having outlined what those sanctions are, fraudsters may not be too daunted by some of these potential consequences, but nevertheless, these orders are important. And ultimately, if they prove to be an insufficient deterrent, it will open the door for the other party to make an application to the relevant court for further sanctions, should the situation require it. One practical point that is worth flagging relates to the drafting of peremptory orders. In light of the nature of the sanctions provided for by peremptory orders, it's very important to ensure that their terms are carefully considered and worded to avoid the opening up of any awards to challenge in due course. So to provide an example of that, if you fail to properly indicate in the order that an unsubstantiated allegation can no longer be relied upon following failure to comply with the peremptory order, if that isn't specified, that ultimately could lead to a party challenging any subsequent award on the basis that its due process rights to have the opportunity to present its case were violated. And so as with much of our lives as lawyers, proper drafting of a peremptory order is key. In terms of practicalities, peremptory orders can arise in various circumstances. So, for example, there was a recent case in England involved a dispute over an ongoing gas supply contract. And during the arbitration, one party stopped paying the other party, which it was required to do under the contract. And in the end, the wrong party obtained a peremptory order requiring that payment be made, which in turn was not complied with, and an order was ultimately obtained from the court. In terms of fraud, as I mentioned, fraudsters can be inventive and use all means possible to delay. This can take many forms, but one obvious area, and I think Mark kind of touched on this earlier, is obviously in the context of failing to comply with disclosure orders in an attempt to conceal their wrongdoing. So in the case, one of the cases that we had, the one that Mark was talking about earlier, we'd obtained numerous disclosure orders from the tribunal requiring disclosure of documents in our attempt to unearth the fraud that we were certain had occurred. However, none of those were satisfactorily complied with. But this wasn't through a total failure or refusal to provide any documents. It was far more nuanced, and again, Mark touched on this earlier. And I think it was sort of two quite interesting ways that was done. And in the first, the respondents initially persuaded the tribunal that a number of the documents were commercially sensitive, and therefore they had to be provided by means of a physical data room. So invoking confidentiality in this way is a clear modus operandi of fraudsters. The respondents were insisting that the sensitivity of the documents required a protocol to be put in place for the inspection in the physical data room. There were thousands of bundles of documents, all produced in hard copy, and the number of people that could go in to inspect them were limited. And when we ultimately looked at these documents, what was clear is the overwhelming majority of them were entirely irrelevant and non-responsive to the documents that had been required to be produced. seemingly in an attempt to obfuscate the few key documents that were. And when we brought these shenanigans to the attention of the tribunal, it was clear that it had a very prejudicial impact on the tribunal's thinking. The second area that they used was to redact, and Mark touched on this, large portions of the documents set out in the data room, to the extent that sometimes whole pages of documents, or almost the entire document, was redacted. So it was almost impossible to tell what the document even was, let alone whether it was truly confidential. And so in the face of that non-compliance, we applied to the tribunal for a peremptory order for disclosure. And in that application, we specifically made it clear that if it was obtained and not complied with, we reserved the right to appoint forensic accountants in the light of that non-compliance. The peremptory order was made and unsurprisingly similarly ignored. And given that non-compliance and our belief that a clear fraud had been obtained, in fact, rather than going for forensic accountants, we went for the more draconian measure of receivers, which Mark is going to come on to shortly, by means of an application to court in order to conserve property pending the outcome of the dispute. And what was interesting about that is we ultimately obtained the receivership order, is that whilst the peremptory order wasn't necessarily a prerequisite to the obtaining of that order, nevertheless, the continued failure to comply with the disclosure orders, the way that the nuanced approach to concealment, and the fact that the peremptory order itself had been made, helped persuade the court, in addition to other evidence, why that order was granted. So in sum, I think peremptory orders are important. They are not going to strike fear in the heart of fraudsters, but they can nevertheless be a useful tool to bring fraudsters into line and potentially pave the way to future court proceedings. Without that, I'll go back to Cameron.
Thank you very much, Gareth, for that overview of the use of peremptory orders and our experience of those. I think it would be very helpful for us now to understand this all from the tribunal's perspective, and we're fortunate to have Chan with us today. So Chan, I have a couple of questions for you on these. The first is, it would be interesting to know what you think is important to tribunals when they're deciding whether to deploy these tools, so the issuing of adverse inferences or peremptory orders. And my second question is, and I don't want to put you on the spot with this, but how frustrating can it be for tribunals recognizing the limitations of these and the fact that it might not be enough to secure compliance? The considerations of futility also come into play when deciding ultimately whether these should be issued. So Chan, if you could address both of those, would be very, very grateful.
Thanks very much, Cameron, and many thanks to the Debevoise team for inviting me to participate in this discussion today and have the opportunity to gather with all of you virtually in Hong Kong. Yes, as Natalie has said in the past, that one of the main limitations of the tribunal is that the tribunal really does not have any coercive powers. And so this really then prompts the questions that Cameron has raised. The first question as to what is important to the tribunal when deciding on whether to draw adverse inferences or issue peremptory orders, and how prejudicial effects might be guarded against, the tribunal will invariably take into consideration the rarity in which adverse inferences are made by tribunals, and also how little teeth there is to such decisions made by the tribunal. Having said that, and as mentioned by Natalie as well, there are certain circumstances where the tribunal may find it appropriate to draw adverse inferences, and in fact recognize that it is helpful, despite the lack of teeth, that adverse inferences be drawn. In determining the circumstances in which adverse inferences should be drawn, the tribunal may take into consideration the following questions. First, has there in fact been a concealment or refusal to produce evidence? Second, was the non-production of evidence flagrant, such as in the face of an order of the tribunal? Third, was the non-production of the evidence intentional? That is, does the party opposing a finding of negative adverse inference know or have reason to know of its obligation to produce evidence rebutting the adverse inference sought. Fourth, were there valid reasons provided for the non-production of the evidence? This speaks to the relevant provisions as set out in the IBA rules that indicate that adverse inference may be drawn where parties fail to produce a document without satisfactory evidence or explanation. Fifth, did the applicant formulate a suitable adverse inference? That is, has the party seeking adverse inference produced all of the available evidence corroborating the inference sought, and is the inference sought reasonable, consistent with the facts in the record, and logically related to the likely nature of the evidence withheld? And finally, what effects will making or refusing a finding of adverse inference have on the final award? Now, these types of questions are ones that will go into the mind of the tribunal when taking into consideration any request for an adverse inference. Certainly this is considered in a holistic manner, and there are certain inferences that may be drawn, but maybe not necessarily expressly so. And so the tribunal certainly has to be mindful of the consequences of drawing such adverse inferences. Now, briefly touching then on what is considered important when deciding whether to issue peremptory orders. The tribunal may take into consideration the following. What is the nature of the peremptory order being sought? Is the consequence by the party an appropriate consequence? And what then is the utility of the peremptory order? That is, even if there is non-compliance, is the existence of a peremptory order enough to start building a record that then ultimately serves as evidence of non-compliance by the offending party when brought to court? And this was explained by Gareth in his example. Now, even if a tribunal were to make an adverse inference or issue a peremptory order, the tribunal knows that without coercive power, such threats may be empty. For the sake of conducting an efficient proceeding, though, the tribunal will want to think carefully as to what can be done to address the potential futility of such an exercise. Indeed, courts will also hesitate before issuing orders that may be futile. So the difference in this instance is that because of the sanctioning powers of the court, non-compliance with such orders could have real consequences. In order to work around the lack of bite of an order issued by a tribunal, the tribunal may wish to implement a few preemptive tools that may be helpful. And certainly these tools really fall into the nature of those that are helpful to ensure that all parties recognize what the consequences are and what their rights are when adverse inferences or peremptory orders are issued. So for example, when anticipating fraudulent behavior or noting claims of fraud in early submissions, the tribunal may wish to expressly indicate its powers to make inferences, adverse inferences, which may be, as Natalie referenced, may be set out in relevant rules and legislation, and the consequences of not complying with such orders in a procedural order number 1, or certainly early on in the proceedings. And secondly, it may be useful to remind the parties that while an adverse inference does not dispense of the claimant's burden of proof, it may be considered as part of the overall assessment of the evidence that the tribunal takes into account. Sometimes reminding the parties as to these consequences may be sufficient to encourage compliance. Cameron?
Thank you very much, Chan. Well, it was definitely useful to hear your perspective as an arbitrator on the use of adverse inferences and peremptory orders. Now, we've been talking already in this webinar for some time about the preemptive steps that you can also take outside an arbitration in cases involving fraud. So it's time they now move on to our second discussion, which is on when and how to pursue various court applications. We're just going to focus on a handful of those. Before we turn on to those, just as a reminder, please do feel free to send any questions in the Q&A box. We've already received a couple, and we will, just in the interest of efficiency, we'll deal with all of those once we've made it through this second discussion. So I look forward to seeing your questions pop up throughout. We'll turn then now to Swee Yan in Singapore, who's going to elaborate further on turning to courts to obtain disclosure orders. Swee Yan.
Thank you very much, Cameron, and thank you to the Debevoise team for inviting me to join the Hong Kong Arbitration Week. I think disclosure orders are extremely important when we're dealing with a case where you're being confronted with fraud. As what David set out right at the very beginning of his introduction, fraud really tests the limits of a tribunal powers. So when we are speaking about disclosure orders, what I would like to focus on today is really focusing on disclosure orders against non-parties over whom a tribunal typically has no power over. And I would like to focus on non-parties such as banks, who would have critical information as to the flow of funds, which are part of the tracing claim or remedy that's being sought, and to focus on, for instance, professional advisors. So one would expect that in such a situation, it would be very important to obtain disclosure orders from these third parties like banks and corporate service providers. While we all know that the tribunals is empowered to make disclosure orders against parties to the arbitration, but what then happens to these third parties? It naturally follows that the tribunals, while they may encourage parties to try to obtain such information, one can expect that the respondent to the arbitration, who is the fraudster in question, would not be cooperative. One would also imagine that to be able to obtain such information from a third parties, it may be important as part of the strategy to have a stealth approach rather than to give the heads up to the respondent in the arbitration that such applications are going to be made. And that is when I think the litigation and arbitration sphere really comes together. And once, even if we are prosecuting fraud in an international arbitration, may see it necessary to seek assistance from the national courts. That now turns to what are the possible disclosure orders that can be sought from the national courts, which obviously would depend from court to court. I would like to cover two main disclosure orders today, the Norwich-Pamukka orders as well as the Bankers' Trust orders. Turning first, Cameron, to the Norwich-Pamukka order. I think all of us who have practiced in court litigation, as well as familiar with the common law courts in UK, Hong Kong, Singapore, all know of the availability of Norwich-Pamukka order, which is used to identify a third party who has information about the wrongdoer. So this would typically be a situation where you try to get information from banks so that you could identify the wrongdoer. To be able to obtain such an order, you must show that the respondent is likely to have relevant documents and information, show a good arguable case of wrongdoing and that the respondent is involved. When you need to show that the respondent third party is involved, it does not mean that the respondent third party bank or professional service provider is a party to the fraud, but just that they have somehow perhaps innocently been tied up with the fraud because their facilities have been used to conceal proceeds of the fraud or to transfer proceeds of the fraud. And of course that the order is necessary in the interest of justice. You must also provide a cross undertaking in damages. All is very well and good. We all recognize the powers of a national court to award Norwich-Pamukka orders in jurisdictions like England, Hong Kong, Singapore. The question then becomes, can a court make a Norwich-Pamukka order in aid of arbitration? And that is a big question mark, even for the national courts who have been very familiar with such orders. And why is this a big question mark? It is a big question mark because if we were to trace and take a look at the arbitration ordinance, whether is it the Hong Kong Arbitration Ordinance or the International Arbitration Act, you would see that disclosure orders are often within the remit of a tribunal. The courts may have the powers to grant interim measures in aid of arbitration. We're talking about freezing orders, We're talking about potential preservation orders, preservation of evidence orders, which you arguably can go under if you're saying you're looking for evidence, or we are talking about disclosure orders in aid of Mariva injunctions. But putting all those aside, what if we are speaking strictly about a novel pharmacal order where you are trying to obtain discovery of documents from a third party to see whether you even are able to make out a case of wrongdoing so as to prosecute a fraud claim in international arbitration? That becomes a very big challenge. And that becomes a very big challenge in many jurisdictions, because what you are having recourse to is not so much about the court's powers under the arbitration legislation, but you will be looking to the court's inherent jurisdiction to be able to grant pre-arbitral discovery. So I want to focus on getting a Norwich pharmacal order, which is before you have an arbitration, when you have an arbitration, and when you enforce an arbitration award. I think we have seen cases where you're enforcing an arbitration award. At that stage, that may be much easier. But a big question mark is, even before you commence arbitration, are you able to get a Norwich pharmacal order in aid? Someone would call it pre-arbitral discovery. And I would say, even under Singapore law, that has proven to be challenging. So some of the ways to get around that, instead of going for a pre-arbitral discovery, may be to consider using other tools of the courts to try to get such an order. And that makes me turn to now the banker's trust order. Cameron, the next slide. A banker's trust order is interesting because, unlike the Norwich pharmacal order, it is specific to banks. It is an order that is made to banks to disclose documents and correspondence relating to their customer who is prima facie guilty of fraud. Again, the bank's liability is irrelevant, but in order to obtain a banker's trust order, what is required at this stage in the sense of the level of proof is much higher than an MPO. You need to actually show real evidence of fraud, and there must be very strong evidence of fraud. You must show that there's a real prospect that the information that you seek might lead to location or preservation of the assets. Other than that cross undertaking and damages, you would also often try to seek a gagging order so that everything is kept confidential. What one would then imagine is that instead of just going for a Norwich pharmacal order, you may think that it is better to have recourse to a banker's trust order. While the standard that's required to show a fraud at this instance is higher, it is more specific, and based on jurisprudence, it seems that the courts are more inclined to grant a banker's trust order because of certain unique provisions that may be around in certain evidence ordinance in various jurisdictions. With that, I actually want to specifically speak about a situation that is quite unique to Singapore. And that relates to a very interesting provision in the Evidence Act, which one should consider how to get around this idea of pre-arbitral discovery in aid of arbitration, how to get around this concept of the International Arbitration Act, not giving courts the power to order discovery in aid of arbitration. And it is this. Section 175 of the Singapore Evidence Act, and interestingly, you can also find this equivalent in Section 21 of the Hong Kong Evidence Ordinance. It's a very interesting provision because it actually just simply sets out that a party can apply for discovery against the bank, notwithstanding the bankers and banking secrecy confidentiality, because it is an exception, and it provides very simply on the application of any party to a legal proceeding. The court or judge may order that such party be at liberty to inspect and take copies of any entries in a banker's book for the purposes of such proceedings. Specifically in the Singapore Evidence Act for Section 175, Section 170 defines it as legal proceeding includes an arbitration. And there, I say, is the beauty in how do you get around pre-arbitral discovery in aid of arbitration? How do you get around the strict requirements of a banker's trust? And I would say to have recourse to Section 175 of the Evidence Act, which has its equivalent in England, which has its equivalent in Hong Kong. And there is a High Court decision known as La Dolce and Deutsche Bank, where this provision has actually been used successfully. In that particular instance, the parties were seeking orders against Deutsche Bank, which is a non-party to a CTAC arbitration, which is seated overseas, not in Singapore. And the court actually found that the court's power to grant the relief sought is not affected by the fact that it is not provided for in the IAA. It is not affected by the fact that it's a foreign seated arbitration, because Section 175 of the Evidence Act gives that ability and gives that recourse. Because Section 175 of the Evidence Act is a provision that stands on its own. There are two decisions that subsequently went up, and the case of Elegant Trading, which is the appeal against the Assistant Registrar's finding that Section 175 gives its remedy, also does not disagree with the Assistant Registrar's decision in this regard. And I think I would just want to end off with a few pointers. I think when we are dealing with fraud, we must understand the tribunal's limitations against non-parties. Because of the tribunal's limitation against non-parties, it is critical for counsel who's involved in this to get creative, to start thinking of beyond what are already known to us, like the NPOs, the Bankers Trust. What else is there in the respective national courts where you are looking at, which may then give you that, opening to try to get more evidence? Because we know it is important, like what David says, to act fast, to act preemptively before the monies are all gone. Thank you very much, Cameron.
Well, thank you very much, Swee Yan, for highlighting those two very powerful tools at the court's disposal. And from our experience, both Norwich Pharmacal applications and Bankers Trust applications can be very beneficial. And for clients, it really can lead to that eureka moment where fraud has been suspected and you are finally able to obtain documents that evidence that fraud. Looking then at a slightly different angle, when you already know where potentially assets are and you're concerned about those being dissipated out whilst an arbitration is on foot, we'll turn now to consider freezing injunctions and the difference between freezing orders issued by tribunals or injunctions issued by court. So with that, over to you, Natalie.
Thank you very much, Cameron. So picking up very much where Swee Yan left off, we are now in the realm of considering relief from courts or the tribunal. Now, in our experience, the court-ordered freezing injunction is often preferable for two reasons. First, the freezing injunction represents less of a tip-off risk. Now, to prevent tipping off, these applications may be made ex parte. So you can have a preliminary freezing injunction without giving the respondent advance notice before a fuller inter partes hearing. That is what is available through court litigation. In the realm of arbitration, however, the rule barring ex parte communications with the tribunal once it is seated means that any application must be brought inter partes. And moreover, there will often be lead time between bringing the application to the tribunal's attention and when the tribunal could ultimately make any order. And that significantly longer lead time could be extended if there is a hearing and submissions from both sides, as often, again, is the case in arbitration submissions. And this may be not just counterproductive, but it may defeat the entire purpose, because it will give the respondent an opportunity to dissipate the assets before an order is made. On the other hand, a court would generally have a duty judge available or otherwise be able to move very quickly, meaning that the order can be obtained at short notice and ex parte, thereby preserving the advantage of movement and moving quickly. The second reason that court relief is likely to be preferable is that the freezing injunction is immediately and directly enforceable, including, again, picking up on points that Swee Yan made, crucially as to third parties. Now, once a court has made an order to freeze assets, for example, a bank account, the party can present that order to a bank and have it instantly enforced. A tribunal's orders, on the other hand, generally would have no similar direct or coercive effects on third parties. Instead, such an order often has to be enforced by a court, which sometimes even requires further intermediate orders being made by the tribunal, again, defeating the purpose. So while parties may avail themselves of both preservation orders and freezing orders, particularly in cases concerning fraud, given the circumstances and the importance of moving quickly to ensure that the assets are there at the end of the case, it is far more common and effective for parties to apply to court for freezing injunctions. Back to you, Cameron.
Thank you very, very much, Natalie. Well, we've heard of some tools at the court's disposal, which may be seen as sort of first preemptive steps to take in cases involving fraud. But there are more extreme cases where you simply will think we must get these assets within our control. And in some jurisdictions, there will be at the court's disposal the receivership process, and that is something which can be used really to rein in the assets and to give you the fullest protection that you possibly could receive from a court. And I'll now hand over to Mark, who will be explaining to us how these work and how you can obtain receiverships in practice.
So thank you, Cameron. So just for the benefit of those persons who are not familiar with how a receivership works, so in Hong Kong and other common law jurisdictions, a receiver can be appointed by a court. Note that it's a court appointment rather than arbitral appointment, to take custody of an asset during the pendency of a court proceeding or an arbitration. And it's a very broad remedy and can include, of course, shares in a company, so that a receiver, who is typically an accountant, can go in, take over the shares of a company, and then, of course, take control of the downstream assets of that company by appointing directors and so on and so forth. So it's a very draconian remedy available to courts. And is only really used in extreme cases, as Cameron has mentioned. So it's a measure of last resort, and something needs to have gone seriously wrong. So, for example, sometimes you will see receivers appointed in circumstances where other remedies which have been granted by the court, e.g. Injunctions, have been breached. But the circumstances in which an order is made and the test that you have to meet in the context of an appointment is quite similar to that in relation to an injunction. I think the only other point I'd make is that not always, but more typically a receiver will be by way of an inter partes application rather than an ex parte application, but it can be done on both bases. Now, what are the sort of strategic advantages of having a receiver? Well, they can be quite strong for a claimant who appoints someone, because effectively it will have the ability of unseating potentially fraudsters who remain in control of a company or an asset. And of course, once the receivers are inside the company, they will then get access to all the books and records and so on and so forth, which previously may have been withheld by that company if it's under the control of the fraudsters. Another strategic advantage in relation to a receivership is that if a company over which a receivership order has been made is a party to an arbitration and is required to comply with any orders that are made by an arbitral tribunal, then experience suggests that having a receiver in place at the time you're seeking to enforce the order is of significant benefit to any plaintiff, because it's unlikely that the receiver will be taking steps to avoid enforcement or to evade the obligations that arise out of an arbitral award. So always worth thinking about, particularly also it's, what I mentioned at the outset that it's a common law remedy. So not only is it available in Hong Kong, but such an appointment can also occur in some of the Caribbean islands as well, where a lot of the sort of cross-border litigation that we're dealing with here does involve BVI or Cayman companies. So it's a well-trodden path and something you should think about. Cameron, let me hand you back.
Thank you very much, Mark. Well, we are now coming to look at the final tool, which might be at the court's disposal. And this can arise where there are parallel arbitration and court proceedings on foot. One benefit of having those parallel proceedings is that if false things are being said to a court or a court is being misled, it may give rise to the scope for contempt proceedings. So I will now hand over to Gareth to elaborate a little on the prospect of those and the benefits they can bring about in cases involving fraud.
Thanks, Cameron. Yes, I'm very briefly going to look at contempt. These obviously won't apply in all cases, but where they are available, they can be an extremely powerful weapon to deploy against fraudsters. I'm sure you're all aware contempt of court is itself an umbrella term that refers to various acts or omissions that are calculated to interfere with the administration of justice. And as Cameron has said, where an arbitration involves ancillary court proceedings, contempt of court could be an avenue of redress where the opposing party has breached court orders or injunctions or otherwise made false statements to the court. And ultimately, depending on the severity of the contempt, if it's found to have happened, it can be punishable by imprisonment. So in our experience, the very threat of these proceedings, the very possibility of these proceedings of itself can be very helpful to bring fraudsters to their senses. Obviously, it needs to be deployed appropriately so that criticisms can't be made against you, but it is a very, very powerful tool. On the next slide, we've set out the test under Hong Kong law. I'm not going to go through it, but I think the things that need to be borne out are it is a criminal offence. The standard of proof is beyond reasonable doubt. And certainly in Hong Kong, but I'd say most common law jurisdictions, it's a very high threshold to meet, not least because you need to show intention. We sort of flagged one issue or difficulty with contempt is that it's contempt of court. So it only applies to false statements that have been made before the court or breach of court orders. And it won't apply to statements that have been made before an arbitral tribunal. And so if false statements are made to a tribunal, for example, in sworn testimony, then that witness would be guilty of perjury rather than contempt. That said, in the context of the sort of claims that we're discussing today for fraud, it's often the case that there will be some form of ancillary court proceedings. And so where the arbitral process can play into that is if any evidence obtained in the arbitration goes to prove that court orders have been breached or may have been breached, or that statements have been made falsely to the court, then obviously the arbitral process ties in nicely with the contempt proceedings, and contempt would definitely be an avenue worth considering. So with that, I shall go back to Cameron.
Well, thank you, Gareth. And so we have now made it through in quite a short space of time, quite a few of these tools that are at the court's disposal in cases and when you may like to turn to courts for assistance. Now, obviously, the prospect of parallel proceedings is not always something to be welcomed. But in these cases, I think what all of these tools demonstrate is that they can be not only useful in cases concerning fraud, but also a real necessity. Again, it would be very helpful to receive an arbitrator's perspective on all of this. So Chan, turning to you, what factors have you seen influencing tribunals' decisions to permit parties to make court applications where sometimes that permission is required for a tribunal. And also, we do know sometimes between courts and tribunals, there can be, egos can be involved to an extent. What tensions have you seen arising between courts and tribunals where there are these parallel proceedings?
Yeah, thanks very much, Cameron, and I appreciate that time is getting on. So I'll just highlight two main factors that I would say influence a tribunal's decision to permit parties to make court applications where this is required. And the first of which is whether the request requires consent or agreement from the parties to the arbitral agreement. It's obviously clear that consensual and private nature of arbitration means that the tribunals lack authority to compel third-party disclosure in the way that state courts have. And under such circumstances, court applications will obviously be the preferred means of achieving what the applicant is seeking. And this is usually well aligned with any orders or directions that the tribunal might make. And the second is that of ex parte communications. Certainly, if ex parte communications would be beneficial to the applicant, for example, parties seeking urgent relief or otherwise are concerned that the offending party may make a move if it catches wind that such an application is afoot, they may wish to go to courts directly without engaging the tribunal. Now, in relation to the tensions that might arise between the tribunal and the courts, I think in general, generally speaking, certainly where courts are pro-arbitration, such tensions are indeed minimal. What is noteworthy, though, is that some courts will look to see if the parties have first approached the court or the tribunals to seek relief. And if the party seeking relief has not, this may lead the court to then refer the application back to the tribunal first on the basis that the tribunal certainly has jurisdiction over the matter and will likely have better information than the court to render such a decision. In this regard, the tribunal will likely want to deal with such matter in a timely fashion, knowing that any relief granted will likely be supported by the court. Certainly, in such instances, the tribunal will not be concerned that courts are encroaching on their territory, so to speak. On the contrary, if courts consider that measures are required, such measures serve to protect the outcome of the arbitration, arbitrators may in fact welcome the issuing of such measures which buttress their own powers in the proceedings. Back to you, Cameron.
Thank you very much indeed, Chan. Well, we have managed to get through a lot of material and we still have just a few minutes remaining for some Q&A. There are a couple of questions we've already received, but feel free now to send any others you may have. We'll begin with a question, I think, Mark, it's probably one that is addressed to you, discussing about what happens when there's abuse of confidentiality restrictions whilst the arbitration is on foot. And the question is, are you suggesting that it's possible to go back to the tribunal during the proceedings themselves for an order, or what happens when the final award has already been issued?
Thanks, Cameron. Yes, good question. The answer is that whilst the tribunal remains functus, then the appropriate body to approach in relation to a relaxation of the confidentiality provisions would, in my view, be to go back to the tribunal. And of course, tribunals do sometimes remain in place even during an enforcement stage of a particular proceedings. If, however, the tribunal has become functus, then it is likely, of course, that the confidentiality associated with the arbitration will continue post the arbitration. Then any application for relaxation would have to go to the court, and in the Hong Kong context, that would be the judge that supervises arbitrations.
Okay, thank you, Mark. We've received another question, which Sui Yan, I think it may be one best addressed by you. And that question is, when will it be necessary or desirable to offer a cross undertaking or damages in the context of making an application for a banker's trust order? Any light you could shed on that would be helpful.
So for me, I would say that as an applicant for bankers' trust orders, I would offer the undertaking because it is both necessary and desirable. As I mentioned earlier, if we were to take out an application against a bank, we would want a stealth approach. You would not want the fraudster to know that you're seeking discovery of information from the banks. So one of the first thing you would naturally do is you would apply for a sealing order or gagging order. So how I would envisage the application taking place is you would file an originating summons both for an ex parte sealing order as well as the inter partes bankers trust orders against the bank. So you will then quickly get your orders sealed so that no one knows that you're proceeding with this application against the bank. And then thereafter, you will give the bank a chance to appear on an inter partes basis to respond to your application for bankers trust orders. And the respondent in question, the fraudster, is not involved in this entire process. So when the fraudster is not involved in this entire process and the bank actually owes obligations to the fraudster on the banker's customer's relationship, it seems almost necessary and desirable for there to be a cross undertaking in damages that's offered to the bank, for the judge to be persuaded that, you know, the bank as a third party, even though it's not in a sense and involved in the fraud as an active perpetrator, is in a sense protected if the customer then turns around and decides to go after the bank because of any breaches of that banker customer's relationship or obligations. So I think it's both necessary and desirable.
Thank you very much, Swee Yan. Well, before we close, we have a couple of minutes remaining. If any of our panelists have any final observations, please do go ahead now. But otherwise, in the absence of any further questions, I would like to thank you all very much on behalf of Debevoise for joining our webinar today. That's certainly been a lot of content for you to absorb, but we hope that's really been helpful, not only to show to you the tools that are at the disposal of tribunals and courts and when those might be invoked, but also the learnings from our recent experience on these issues. Thank you again to Swee and Chan for collaborating with us today, and to our Debevoise partners over in New York from joining us here in Hong Kong. We look forward to seeing you all soon. In the meantime, take care, and thank you again for joining us. Goodbye.